Welcome to this presentation on an overview of the duty to accommodate. This is the first of 3 webcasts describing the duty to accommodate in the workplace. My name is Carolyn Ormsby, and I will be hosting this webcast along with my colleague, Jessica Snow. We are both with the Alberta Human Rights Commission. Please note that the human rights legislation referred to in this webcast is the Alberta Human Rights Act. The commission referenced is the Alberta Human Rights Commission. If you have a human rights concern with an organization that falls under federal authority, or if it falls under another provincial or territorial authority outside of Alberta, check with the federal, provincial, or territorial Human Rights Commission in that jurisdiction for more information. It's important to note that the information presented in this webcast is not legal advice. It's information to increase your understanding of the Commission's duty to accommodate process under the Alberta Human Rights Act. I'll now hand this over to Jessica.
Thanks, Carolyn. This webcast will help you gain an understanding of the duty to accommodate, as well as the rights and responsibilities of employers and employees in the accommodation process. The key concepts in the duty to accommodate are the areas and grounds of discrimination in the Alberta Human Rights Act, undue hardship, and bona fide occupational requirement as a defense to discrimination. The Alberta Human Rights Act upholds the principle of equality in Alberta. It protects individuals from discrimination under specific areas and grounds, and it establishes the Alberta Human Rights Commission.
Thanks, Jessica. What are the areas and grounds in the Alberta Human Rights Act?
The protected areas in the Alberta Human Rights Act are statements, publications, notices, signs, symbols, emblems, or other representations, goods, services, accommodation, or facilities customarily available to the public, tenancy, employment practices, employment applications and advertisements, and lastly, membership in trade unions, employers' organizations, or occupational associations. There are 15 protected grounds in the Alberta Human Rights Act under which discrimination is prohibited. They are race, religious beliefs, color, gender, gender identity and gender expression, physical disability and mental disability, age, ancestry and place of origin, family status, marital status, source of income, and sexual orientation. The Supreme Court of Canada has ruled that an employer has a legal duty to take reasonable steps to the point of undue hardship to adopt policies or conditions of work to accommodate an employee's individual needs based on a protected ground. This duty applies to all the protected areas and grounds in the Alberta Human Rights Act.
What is accommodation, and when does the employer have to think about it?
Accommodation ensures that all employees have equal opportunities to participate in the workplace. Therefore, an employer needs to consider accommodation in all aspects of employment, including in their hiring practices, in their assignments and work duties, and when planning meetings and professional development opportunities and social events that are employment-related.
Thanks. What does an employer have to do to accommodate an employee or potential employee?
Accommodation means making reasonable changes to certain rules, standards, policies, and the physical environment to ensure that it doesn't have a negative impact on employees based on a protected ground in the Act. Each case for accommodation is unique. The employer must look at each request for accommodation to determine how and whether it can reasonably provide the accommodation that is requested.
Jessica, I think you have some examples of how accommodation can be provided.
There are many examples of workplace accommodation. Some common examples include purchasing tools or modifying equipment or aids to assist an employee to do their job, modifying the workplace to make it accessible for people in wheelchairs or those with limited mobility, or designating parking spaces and drop-off areas for people with disabilities. For example, providing a parking spot close to the entrance so an employee with limited mobility doesn't have a long way to walk to the building. Other examples could include allowing day shifts instead of night shifts for parents with childcare responsibilities, or for a single parent who doesn't have anyone to share childcare responsibilities, providing time off for religious events, and relaxing a requirement to wear full uniforms so an employee can wear a hijab with their uniform if needed.
What if the employer doesn't want to accommodate an employee because it's too much of an inconvenience?
It's not up to the employer to decide if they want to accommodate the employee. Accommodation is required by law and is not a courtesy afforded by the employer. Failing to provide accommodation may be a contravention of the Alberta Human Rights Act, and the person who is denied accommodation may have the basis to make a complaint to the Alberta Human Rights Commission. The courts have said that providing an accommodation may require a degree of inconvenience, disruption, or an expense to the employer. But employers are expected to provide reasonable accommodation to the point of undue hardship.
What is meant by undue hardship?
Good question, Carolyn. Undue hardship occurs if accommodation would create onerous conditions for an employer. For example, intolerable financial costs or serious disruptions to the business.
When an accommodation is requested, who is responsible for ensuring the accommodation is provided?
The duty to accommodate is a collaboration between the employer and the employee requesting the accommodation. In unionized work environments, the union should also be included. The employer, the employee, and the union all have responsibilities in the accommodation process. The employee initiates the accommodation by making their needs known to the employer, and the employer works with the employee and the union to find the best accommodation option or shows undue hardship. An employee is entitled to reasonable, not perfect or preferred, accommodation. Large employers may be required to look for reasonable accommodation in other departments or locations.
Jessica, describe the role of unions in the duty to accommodate in unionized workplaces.
Sure. Unions are also expected to cooperate in the search for reasonable accommodation, even if in some cases that accommodation is contrary to the collective agreement.
This leads us to the role of employees. What is their role in the duty to accommodate process?
The employee has the following responsibilities in the duty to accommodate. The employee requiring the accommodation must first make the request for accommodation. They must state the need for the accommodation, make the request, and provide relevant documentation, such as a medical note from a physician identifying the accommodation required, like the work restrictions or suggestions for accommodation options, if any, and inform the employer of the length of time the accommodation is required. The employee then allows sufficient time for a response and then considers any reasonable accommodation options that the employer proposes. The employee has a responsibility to accept a reasonable accommodation, even if it isn't the one they prefer. Employees must also cooperate with the employer to make the accommodation work. They need to advise the employer when the accommodation need changes. Employees must also provide documents to support the change in the accommodation need and assist the employer in modifying the accommodation. Lastly, they must inform the employer if they no longer need the accommodation.
When an employee requests an accommodation, what are the employer's responsibilities?
Once an accommodation request is made, the onus is on the employer to consider all reasonable options for accommodation, unless they can show that it is an undue hardship. The employer must determine if the accommodation request is based on the areas and grounds under the Alberta Human Rights Act, respect the dignity and privacy of the employee requesting the accommodation. Keep in mind, medical information is considered personal information, and the employer must abide by applicable privacy legislation when they collect, use, or disclose the information. The employer must also ask for and review the medical information provided by the employee. The employer is entitled to know the prognosis, not the diagnosis. Consult with an expert, such as a human resource professional or lawyer, to determine whether more information is needed to assess the request. Additionally, employers should discuss the available options for reasonable accommodation with the employee requesting the accommodation, taking into consideration the limitations of the employee, their qualifications, skills, experience, and work history. They should also respond to the request within a reasonable period of time. Once an accommodation is agreed upon, make a formal agreement with the employee. This will ensure that both parties understand the terms of the agreement. Follow up with the employee to find out if the accommodation provided is working or changes need to be made. Be willing to review and make changes to the accommodation as needed. And, if the employer is unable to provide the accommodation, provide reasons and explain the undue hardship that the company would face if the accommodation was provided.
Thanks. Now, are there questions the employer should consider to assist in providing an accommodation?
Yes, the employer could consider the following questions when an accommodation request is made. Why is the request being made? Is the request for accommodation based on the areas and grounds of the Alberta Human Rights Act? Who needs to be involved in the accommodation discussion? Human resources, a manager or supervisor, or unionized representative, if it's a unionized work environment, or a lawyer? How will the accommodation be provided? That is, would it be a job modification, providing special tools and equipment to do the duties of the position, making the workplace more accessible, job sharing, or any other options? And what are the implications of accommodating the employee? That is, how much will it cost? What is the impact of the collective agreement? Does it impact other employees? And are there any safety concerns? Further, if it's a unionized work environment, consider if the union is being consulted. And last of all, is there any undue hardship that would be caused by providing the accommodation? I'll now turn this back to Carolyn, who will describe some of the resources that are available from the Commission.
For more information or to access our resources, please visit our website at albertahumanrights.ab.ca. The Commission has materials that can be downloaded, such as our information sheets titled Protected Areas and Grounds under the Alberta Human Rights Act, Employment, Duty to Accommodate, Obtaining and Responding to Medical Information in the Workplace, a Summary for Employers, and Obtaining and Responding to Medical Information in the Workplace, a Summary for Employees. We also have more in-depth resources, such as our Human Rights Guides, titled Duty to Accommodate Students with Disabilities in Post-Secondary Educational Institutions, Defenses to Human Rights Complaints, and lastly, Obtaining and Responding to Medical Information in the Workplace. You may wish to view our webcast on the Alberta Human Rights Act, as well as the other two webcasts in our Duty to Accommodate series. They are Undue Hardship and Bonafide Occupational Requirement. Find those and other Commission videos on our YouTube channel at youtube.com/Alberta Human Rights. You can also link to our channel from the e-learning page on the Commission's website. If you have questions on a specific situation, or if you want to determine whether you may have the basis to make a human rights complaint, please phone the Commission's confidential inquiry line. If you're north of Red Deer, call the Northern Regional Office at 780-427-7661. If you're south of or in the city of Red Deer, call the Southern Regional Office at 403-297-6571. To call those numbers toll-free within Alberta, you can dial 310-0000, then enter the area code and the phone number. This brings us to the end of the presentation on an overview to the Duty to Accommodate. thank you for your interest in human rights-related issues. We hope that you will join us again for future webcasts.